Hi, good afternoon. My name is Anna Melander. I am the Director of Marketing for Volpe Koenig. We are a full-service intellectual property firm based in Philadelphia. Well, welcome to our June webinar. It's called The Pace of Prosecution. This course has been approved for 1 CLE credit by the Pennsylvania CLE Board. But please stay on the webinar until the end of the program so your attendance can be verified electronically. Volpe Koenig will report your attendance to the Pennsylvania CLE online portal. And all attendees will get a certificate of attendance. You'll be receiving that by email in the next few weeks. So right now, if you would kindly go to the handout section, you'll see a PDF version of our presentation today and also an evaluation form. We'd really appreciate it if you could download that and send it to us. Everybody is, familiar with the format. You're all in, all attendees are in mute mode. Certainly, if you want to ask questions of the presenters, go ahead, pop that in the chat or pop that in the questions. The presenters will be taking questions periodically throughout the webinar. Let's see, I think that's it. Now I will turn it over to shareholder and patent attorney Wes McMichael. Wes.
Hi, good afternoon, and welcome to our CLE webinar. And you should see Ed Labar and I on the screen. Josh is sorting out a webcam issue. Maybe he'll pop up or not. It's too bad. He's one of the better looking patent attorneys we have. Nevertheless, he's got a good presentation for us. So today we're going to talk about controlling the pace of prosecution, and this is going to be a kind of the first of what I expect to be a multi-part webinar series that we're going to do with Volpe Koenig here regarding strategic prosecution, and we'll talk a little bit about what that is. But I think controlling the pace of prosecution is something that we often maybe don't think about at like a global level or strategically, and I'm excited to kind of dive into the nuts and bolts of it and really kick around some scenarios and strategies and things maybe you haven't really thought about in a while. So I'll introduce myself. I'm Wes, Wesley, if you want to call me by my full name, and I'm a shareholder of Volpe Koenig. I've been practicing for about 18 years doing patent prosecution. I have a physics background, and but have done a significant amount of telecommunications and standard essential patent work, as well as a lot of computer software networking and all different aspects of electrical technologies. And with that, I will introduce my colleague, Ed Labar.
Hey, everyone. Thanks for joining us. My name is Ed Labar. I work with Wes on a lot of the same subject matter at BK. I've been with BK I'm in my 9th year, and I worked at another boutique prior to that, and also as an examiner at the USPTO. My technical background is in electrical engineering, and I worked as an engineer designing integrated circuits in the physical design side. And we also work together with our colleague Josh, who you can't see right now, but maybe Josh will tell us a little bit about himself.
Yeah, thanks, Ed. Thanks, Wes. Yeah, I do apologize for not being present during this. But I am present, I'm just not visible. So I've been an associate for 3 years with Volpe Koenig. I've been with the firm for 5 years total. I work with Ed and Wes on a lot of the same types of applications, mainly in the electrical space. But I'm excited to share with you today's presentation.
Great. Thanks, Josh and Ed. And I think particularly I'm excited to have Ed here with his PTO experience, because a lot of what we're going to talk about with controlling the pace of prosecution is really about the tensions that exist between the client's objectives and the patent office's objectives. So to kind of give you a better overview of today's program, we're going to look at first why it's important, why we like to control the pace of prosecution. Then we'll look at the patent office, kind of the status of pendency, how they're doing, and what their objectives are relative to the pace of patent prosecution. Josh will cover the section on how to slow down prosecution, different initiatives, techniques, programs that the PTO offers, and we'll go through those. And then what should say hitting the gas is now says hitting the was. But Ed's going to cover accelerating patent prosecution, and then we'll wrap up with a few takeaways at the end. at the time, I would also, Anna mentioned this, I just would definitely encourage, like, we all have different experience. If you want to chime in the chat, we'd love to hear. We might even ask for some responses. A lot of these programs don't get used often, so we might be interested to know if you have tried something, or if you've tried something that didn't work. We'd like to hear that too. So I mentioned a little bit about strategic prosecution, and this is kind of one of the pillars of patent prosecution of Volpe Koenig. Is we try to align the goal of prosecution should be aligned. Everything you do in prosecution should be aligned with your business objectives, and this would include timing. But I think that when you work, particularly when you work within one portfolio, and I know a lot of you on the line are in-house counsel, and when you're working with one specific technology or one specific strategy, you often kind of forget that there's all kinds of reasons that different companies file patents and what their business purpose for having that patent is. Sometimes it's just a company wants it for marketing purposes. They want to say, oh, this colander is patented. They want to say, whatever widget is, it's patented technology. That's going to be a much different strategy than a more sophisticated high-tech company that wants to get this claim so that they can take all of their competitors, to the ITC and force them out of the market. So be mindful of that. I think we'll look at this from a variety of different lenses and some examples, just to get your head thinking outside of your normal comfort or your normal box. So startups, we get the startups request. They want to get the patent as fast as possible so they can show their investors that their tech is patented, and they can get financing with that and funding, and at the same time, they don't want to pay for anything that's going to speed up prosecution, and sometimes they're on a complete shoestring, and they just want to defer everything as long as possible because they can't experience any cost events until they're down the road and have a viable product. So there's a lot of different ways we're dealing with startups there, different objectives. High tech companies, so if you think about technology, computers, cell phones, they're all in this picture here, tablets, things like that. For the most part, we talk about a 20-year patent term, and for a tablet, it's not gonna last for 20 years. So that 20-year patent term is irrelevant. Now, if you're talking law firm computing systems, those last for at least 30 years. So we're gonna, but most cases, high technology, the 20-year patent term becomes somewhat irrelevant, particularly as you compare it to life sciences and biotech and pharmaceutical stuff, where the FDA process takes so long, and if you're a biotech company, you're going to make all your money off this patent in what could be the last 2 or 3 years of the patent term, and absolutely not during. Can you use any tactics in prosecution that are going to eat into your patent term extension? They're looking at situations where they'll spend whatever it takes, but they want to make sure that there's no applicant delay, that it's all coming from the patent office, and hopefully they can arrive at the end with a significant patent term extension too. So another scenario we see frequently, companies where there's an active infringer, and that's just again, they're already spending the money on litigation. Money is not an issue, and they want to go as fast as possible, hammer down whatever it takes. We just need this patent quickly. And then sort of the utility players would be standard essential patent owners. They're trying to go slow while standards are developing, and and then after a standard is solidified and they can see whether their invention has been captured by the standard or adopted by the standard, then they're trying to hit the accelerator and get those standard essential patents as quick as possible. So there's just kind of totally different business models, totally different objectives. And we're going to roll through the techniques later that all of these companies may use to either speed up or slow down, and we'll look at different strategies that way. Okay. So now we're going to show, oh, wait, this is great. All right, good. We've got our first poll question. So I hope you're all ready to participate. It's pretty self-explanatory. In your current patent strategy, do you mostly push them through as fast as possible? Do you try to slow them down? Some of both? Or do you just sit back and let the patent examiner and the patent office take control of the pace? I'm missing my graphic here to see where it's coming in. Okay.
Looks like we have a good mix.
Okay, you can see it. I can't see it.
Yeah, so it looks like 20% go as fast as possible, 40% do a little of each, and 40% just let the patent office control it.
Okay. I'm sorry that I can't see it, but okay. All right, so are we back to my screen then? Okay. All right, thank you. Sorry for the backup. Okay, well that's, yeah, so as we would expect, and I think, but again, when you're working in a particular silo, you may not think about the other side as much, and you may not think about it, but now hopefully you'll walk away with some tools that you maybe hadn't thought about before. So I want to look at it a little bit too from the patent office perspective, because this is our partner. I won't say this is our adversary. This is our partner in obtaining patents, and Ed will give us some color on that. But sort of, what does the patent office say? What do people say? And I think I have a few quotes in here. One's from the 2010s study by the London School of Economics. Now at that time, those of you who've been practicing a longer time, there was a significant backlog at the patent office. Since around that 2010, the patent pendency, the average patent pendency has dropped 30%. So they've been focused on that. They recognize that the delays in getting patents is costing the economy money, because businesses are waiting for patents to launch products or to fund people, and all of these jobs. These are all jobs too. Every one of us here has a job in the IP industry, and those are jobs people want. They're good jobs. So talk about creating jobs, talk about growing the economy. Getting patents through is generally believed to be an important part of growing a high-tech economy, which is an economy you want. So Judge Michel said that around that time too, the greatest problem with our system was delay. And then even now, when you look at the USPTO website, they say fast innovation is America's competitive edge. So everybody at the USPTO is thinking fast, 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 right? So I got Dwight Schrute there on the side. Clients are thinking slow and steady. We want to see where this goes. We want to see which version of our product we launch. We want to see what our competitors are doing. Patent office say, no, get going, you got to go. So so every year we've seen a lot of different programs over the years come out from patent offices. From the patent office, a good example would be the patent prosecution highway that was done more at the PCT level and adopted and by the US, and I think that's a great tool we'll talk about more. There was pre-appeal conferences. That was a program that was rolled out at some point with the idea that this may be a way we could shorten the pendency and reduce the backlog and make things more efficient. A couple that are coming up that have been proposed. One recently, the electronic patent issuance. So the idea being maybe we don't need all those paper patents, particularly now that we're working at home, or in various different places. They still have an issue notification, and then there's 2 weeks, or where the publication department actually gets their act together to publish and print and mail the patent on the issuance. So getting rid of that period right there could save a significant amount of time. Now I'll change our continuation practice perhaps if that comes, but again, that's all. It's with an eye of reducing paper and that kind of stuff as well, but also with an eye towards speeding things up. And you know, similarly, there's a couple articles out there about the AI tools they're developing for patent searches, and we've probably seen some of those in our own practices as well, and they do make things you know, more efficient. And then there, you know, another specific program that was just rolled out is a deferred subject matter eligibility program. And you know, there's a lot out there, and there's constantly new ideas for how to go faster. So I want to talk about how they're doing. And we talked about, I gave you that statistic. It's down 30. The pendency is down 30% since around the 2010 period. It's gotten faster, but and we'll look at this, some more current statistics. These charts are all over the last 2 years, and they're coming from the patent office. And I think they've had a little bit of an issue, a little uptick in COVID, and we can talk about why that was. So this first chart, and again, these came from the patent office, so I apologize for the funny axes. And this first one is a little bit hard to understand why there was no data before February 21. But what you can see here pretty clearly is that there's an obvious trend that the time it takes to get that first office action is growing, and that's a clear trend. They're not picking the cases up as fast as they were, and I, you know, there's a lot of different reasons why that might be. So if you look at the total pendency time, this is how long the patents are pending, you know, on average across the board, all tech areas. And so this shows it, you know, there's a trend that it's slowing down. You can see, you know, early on in COVID, and we know pretty much, I would say, you know, the trend before March 2020, it was coming down. It had been coming down for the last 10 years. What we've seen here is that perhaps there's a little bit of a shift up, a little bit of a trend that it's taking longer to get patents through their total pendency. It doesn't look as dramatic as that first action slide I put up, but anyway. So here's another interesting way to look at it. So this is pendency from RCE filing to the next office action over the last 2 years, and this has come down. So that's interesting, right? So maybe what we're seeing is that the examiners are prioritizing cases that already have an RCE. So if you file an RCE, they might be they're picking them up faster than they used to. So that's just, you know, something to keep in mind as a data point. So this is total pendency from the filing of a first amendment to the next office action. So how long does it take to get a next office action after an amendment? And that's coming down. So to me, what that says is that it's taking longer for examination to get started, but once it gets started, it's going faster. So just, you know, again, everybody's practice is different, everybody's strategies are different, but it's helpful sometimes to know these things, that, you know, if you're worried that a case took way too long to get picked up, it might happen quicker. And then this is kind of the overall patent application inventory, and again, these slides came from the PTO, and I still think that the colors are switched, but at any rate, I will explain it. So the lighter yellow bars that are stepped up, those are patent applications filed over the course of the fiscal year, right? So the patent office fiscal year ends at the end of September. So you can see that you know, at the end of each September, that number drops back down and they start counting up again. And if you look at the lower trend line, I just circled April from 20, April from 21, April from 22. You can see maybe new application filings are down slightly in a year-over-year first quarter analysis, but there's probably not much to read into that. But what you look at in the more darker brown, those are the total applications pending at the patent office, right? So there's always applications that are coming out of that group, and there's always applications coming in. And if they could show cases having final disposition, it would look sort of similar. It would sort of look like the inverse of the lighter yellow of the application filing. But what you're seeing is that brown is trending, the dark brown is trending up. So there are more cases pending. There's a bigger backlog at the patent office than there has been more recently, and that's a trend over the last 2 years. And since I got this from the patent office website, I'm sure that they're looking at these trends and trying to figure out how do we get that. They, at the minimum, they want to keep those brown lines flat, and ideally they probably would like to reduce their backlog a little bit for all of the reasons that innovation drives everything else in our economy. So conclusions on the patent office objectives: that the patent office wants to dispose of applications quicker. They've maybe been falling a little behind during COVID, maybe just sorting out. Maybe it's, I mean, they were already working from home, so you wouldn't think they'd have too many issues, but obviously the world's had all kinds of different developments. But I do think we can expect new programs, new initiatives. We have a new PTO director. I expect we'll see new attempts to provide initiatives and programs. Some we may see, some may be in the back room, you know, by exam, you know, really more on the examiners. You know, Ed, you had an interesting anecdote about how the patent office would solve this problem in the past, and
well, yeah, I mean, sometimes it's not even a matter of special programs. You know, when the PTO has the budget, they'll go on a hiring binge sometimes, and that's how a lot of examiners get hired. Is that, you know, when they have the resources, they'll just vacuum up a lot of people and get them working on the stack of the backlog that they have. But they don't have control over their budget all the time. So then hiring gets shut off for a while, and they have attrition, and then they have fewer hands working on the pile, and the pile grows again. So that's sort of the dynamic.
Yeah, and certainly the market for patent professionals is hot right now. So if they're trying to hire, that's you know, they're going to have the same challenges, I'm sure, that everyone else is right now, and maybe that backlog keeps growing, but maybe they come up with some new initiatives. So that's the kind of the state of the patent office and their objectives, and where we're headed with respect to the pacing of prosecution. So now we're gonna transition to kind of the nuts and bolts, and I'm gonna hand control of the presentation to Josh. Okay, Josh, you should have control.
I believe I do. Great, thank you for,
Right,
hang on one second. Okay, yeah, we're good. All right.
Josh, hold on, I need to borrow the mouse for a second.
Okay.
Okay, there you go. Sorry.
Thanks. All right, so yeah, thanks for setting the stage, Wes. Again, I do apologize for the technical difficulties on my part. I would like to start with a polling question for the practitioners, the portfolio managers out there. You know, if you have found yourself needing to slow down prosecution, what was your greatest concern in doing that? So I don't see any results yet. And maybe that's an indication that no one has really needed to slow down.
No, they have voted.
Okay.
I'm seeing it. I'm not sure why you can't see it. So maybe there is a tech right now. Let's see. All right, so Josh, what I'm seeing, well, they're still voting. Oh, I see. There's a timer on it. They're still voting. It's still coming in.
Okay.
Just give me like 5 more seconds.
So right or wrong answers here?
All right, Josh, apparently I'm just going to have to read it. It's not coming up. We have 27% expense, 18% delaying as long as possible, 27% potential loss, 0% ethical concerns, and 27% flexibility in choosing when, how.
Okay. Sounds like some folks may not be reading up on their case law, but or maybe they're just going about it in a way that's you know, doesn't pose any concerns ethically. So in any case, I'm going to focus on specifically on the potential loss of patent term and the ethical concerns. I'm going to touch on everything else, but I just want to speak a little bit about patent term to start. So patent term, as we all know, 20 years from the filing date. Now that includes the time required to prosecute the application. And obviously prosecution is not fully within the applicant's control, which is why we have patent term adjustment. Now PTA extends the patent term to compensate for delays caused by the patent office. We get delays awarded when the office doesn't issue an action or respond in a timely manner. And then we get days back also when the office fails to dispose of the application to issue it or to cause it to go abandoned within 3 years. And that can be very valuable. So just to provide an example, Lipitor is the brand name for the drug called atorvastatin. That is a cholesterol-lowering drug that was synthesized in the 80s, patented and brought to market in the 90s. And while its patents were enforced, it brought in over $100 billion in sales. One of the highest selling drugs of all time. But just to put that into perspective, $10 billion of that came in 2010, just before it went generic. So I think Pfizer would have liked to have an extra year or two in PTA. Maybe it did have PTA, but I'm sure it would have taken all that it could get. So on the other hand, delays caused by the applicant can take away PTA that may accrue. Regulations provide basically a laundry list of actions that count against the applicant in the calculation. And those generally focus on failures by the applicant to take action within a specified amount of time. Interestingly, those do little to capture acts by the applicant that cause delay by the examiner in turn. And there are lots of ways that could happen. For example, an examiner could be buried in IDSs. The claims could be very difficult to analyze. And generally, more work for the examiner leads to more delays caused by the patent office. Now, does this raise a possibility for abuse? Absolutely. And the real question is, when do these actions go too far? So the Hyatt versus Hirschfeld case is one cautionary tale. In the spring of 1995, the applicant Hyatt had bulk filed 381 applications in a span of a few months. Then to delay prosecution, he filed amendments adding roughly 115,000 claims, with roughly 45,000 independent claims. Generally uncooperative during prosecution, and basically the PTO becomes so overwhelmed that it has to create a separate art unit with 12 full-time examiners just to examine Hyatt's applications. So this is part of a classic strategy called submarining, where the applicant keeps applications pending and unpublished to one day surprise an unsuspecting target. So years later, the PTO has gotten fed up and rejects his applications. When Hyatt finally decides that he wants his patents, he takes his case to the district court, basically to compel the PTO to issue him his patents. Goes up on appeal. The Federal Circuit holds in favor of the PTO on the basis of prosecution latches. So prosecution latches requires a showing of unreasonable and unexplained delay, as well as prejudice. So here, Hyatt's actions were deliberate attempts to make his applications impossible to process. And at one point, this has cost the PTO $10 million over a span of 5 years, just to process these. Meanwhile, Hyatt's only paying $7 million in fees over that course. There's a number of different actions that he took during prosecution that caused unreasonable delay that the court looks at. I don't need to go through all of them here, but basically, taking these strategies during prosecution, claim filing strategies, filing excessively long and redundant applications, and generally making life difficult for the examiners. So some of the main takeaways from the Hyatt case, if you do need to delay prosecution, maybe you should do it in a way that avoids burdening the PTO. And if you don't, you could face a number of consequences, such as not getting your application issued, as we saw, having to forfeit an issued patent, or if you're in an infringement action, you could have your patent deemed unenforceable. Just to be clear, Hyatt is definitely an extreme example of unreasonable tactics, but interestingly, these didn't violate any rules or regulations. which I think is all the more reason for applicants to exercise caution when they are trying to slow things down and make sure to not get carried away. In any case, you know, a good practitioner knows that it's you should be getting you should be trying to get the examiner on your side and not to intentionally make their lives difficult, because they could be subject to time constraints on their side. Fortunately, we do have an examiner on our panel. Ed, do you have anything to add to that?
Oh, I agree. Obviously, it's always more efficient in every respect to have a constructive kind of cooperative relationship with an examiner. That's true for examiners too. So whether you're trying to slow down the prosecution or speed it up, getting high quality claims in good order.
So Ed, I get that, and I hear that, and I hear that I practice it particularly with trying to get the examiners to go faster without paying for it. And I'll call them and say, hey, did you look at this? Is this on your docket? That kind of thing. As anybody, and if you've done this and it's in the chat, you feel free to put it in the chat. But what do you think, Ed, about the idea of just calling the examiner and say, hey, could you not pick that up for a few months?
I don't think
letting that sit as long as you can.
Well, first of all, I don't think you'd want to do that. That probably skates around some ethical concerns, but also, you should be aware that examiners have deadlines too. So the examiner has limited amount of time to pick up an office action and act on it before they get disciplined in different ways. So, even if you were going to do something like that, I'm not sure it would be particularly effective. So nothing to recommend that, I don't think.
Great.
I will say in my experience, when I've noted to an examiner that I didn't want to move prosecution forward as fast as they wanted to, that they were understanding of that scenario, and I would say weren't too pushy. It was a pleasant interaction overall. So with all that said, I think we can move to our list of delay tactics. We'll see if the slide is going to change.
Yep. I may need to click in for you. Might have rolled over one.
Oh yeah, no, it's just a little bit of delay. Okay. Yeah, so I do want to touch on RCEs and extensions first, because these are sort of garden variety ways, or pretty standard ways of extending prosecution. The RCE is typically used by necessity to keep prosecution open after a final rejection. And sometimes, you might file an RCE after allowance if you really need to get an IDS considered. But it can also be used as a delay tactic. So, example, you get an allowance and you're not really interested in the claims, but you want to keep the application open. You can file an RCE with amendments, maybe to change the claims. There are reasons why this is not the best tactic. I think first, because applicants who file these RCEs after allowance are considered to have failed to bring prosecution to conclusion. So what that means for purposes of the PTA calculation, if you would file this RCE after allowance, any PTA that would be awarded for the office's failure to dispose of the application within 3 years, that goes away. You basically lose that. And the second reason why I don't think it's a great tactic overall is that they're just better options from a cost perspective. So for a large entity, obviously, fees can approach the cost for filing an entirely new application, but filing an RCE is only going to buy you 4 to 6 months on average. So at that rate, if you're not interested in getting the claims allowed, maybe it's more cost effective to just, abandon the application and pursue something different in a continuation. Now, as for extensions, these can be obtained in the range of 1 to 5 months when responding to an action. The real advantage here is that you get some flexibility with timing. You can basically extend as you go and extend it however much you need. But I mean, the real downside is cost. If you're paying for an extension of time for 5 months and you're a large entity, you're paying over $3,000. And at that point, from a cost of effectiveness standpoint, it might not make sense.
Josh, one just important takeaway here too is you touched on it, but I want to really make sure it was emphasized and clear. Going back to look at those graphs I had up earlier, once you file an RCE, you're going to be getting office actions quicker, versus first actions are sitting much longer now. So just something else to think. If you're filing an RCE, do you consider maybe we pay a few bucks more and file the continuation, and that may actually buy you significantly more time than you kind of using the RCE as a delay tactic, for really not that much different in price.
Right, especially if you've already filed RCEs in the past and you're at your second or later. Yeah, it can buy you, it can be more cost effective for sure. So moving on to our next tactic, provisional applications. I think most practitioners know, or any practitioner knows that it's not going to mature into an enforceable patent. Really, these are used to secure an early effective filing date against the prior art, and to basically serve as a placeholder for a non-provisional. Because the applicant has a year to file that non-provisional, then this option effectively buys you a year. But what's most significant, I think, from the PTA standpoint, or from the patent term standpoint, is that when claiming the benefit of the provisional, that 12-month period doesn't count for the start of the calculation of the patent term. So the patent term instead begins when you file that non-provisional, not when you file your priority application. So priority date and filing date aren't necessarily the same thing. There is also a procedure for converting a provisional into a non-provisional, but I don't know of many circumstances in which an applicant would want to do that. And in any case, you basically lose that extra year of patent term that you've gained by filing that provisional application. I think the only time you'd want to do that is if you're applying for design patent protection and you need a priority claim. Okay, so next up we have the PCT application. This provides quite a lot of delay, up to 18 months by itself or 30 months with a provisional application. The real downside to the PCT is obviously it's the cost. It's going to run in the thousands of dollars range, and potentially can be significant depending on how many jurisdictions you enter into in the national phase, because after all, the PCT application is designed to provide easy access to the global patent realm for applicants. So one of the main benefits of the PCT application is you get a practice run on examination. You have a search authority basically examine the claims and give you an indication whether it's going to be allowable or not. You can respond, you can file amendments during that period. But really what's important is that you can influence the claim drafting strategy at the national phase. So if something's going to be allowable, but you're not ready for it to be allowed, then maybe you broaden your claims out, or you go with a different embodiment. And so I think that brings us to our next one nicely. Next strategy would be just claim drafting. So the Hyatt case teaches claim drafting can be no doubt weaponized to achieve very lengthy delays. Applicants are wise to be careful about not taking that too far. That said, there are legitimate ways of claim drafting to maybe influence the pace of prosecution. You want to avoid presenting easy allowances, and when you receive an allowance on the first action, that's not a scenario you want to find yourself in when you're trying to delay, because you have to pay the RCE fees to keep it pending if you choose to keep it alive, and you also hurt your chances at getting PTA. You also want to avoid drafting claims so broad that the examiner can pick up any old reference and cite it against you, make it an easy rejection. Another claim drafting strategy is to steer applications toward a slower art unit by including certain terminology in your claims and in your specification. So there are certain proprietary tools that many law firms and in-house departments subscribe to, Lexis, Juristat, Patent Buddy. But basically these help you develop that language. And an example of this, say an applicant has an invention relating to using AI for bioinformatics applications, whatever they may be. Art Unit 1631 may be one art unit that could examine the application depending on the language and the specification and claims. On the other hand, you could have your application sent to Art Unit 2129. And we see here that, the statistics instead of in terms of timing, with the exception of time to first action, are very different. So overall pendency is going to be over a year longer as of today in Art Unit 1631 on average. Also, the allowance rate in 2129 is almost double. Almost double what the allowance rate is in 1631. So, I think this is a strategy that's more often used to speed things up. But this is an example of how it can be, slowed down. I'm going to move through the next few quickly because we're running short on time. So restriction requirements, these are issued when claims are directed to two or more patentably distinct species. What's an advantage here is that the costs are minimal. It's fairly easy to do. It's just a matter of claim drafting. But it effectively can buy you an extra 3 to 8 months due to the amount of time required to respond to the restriction requirement and then for the examiner to issue first action. And that can go up depending on if your claims are redirected to another art unit. Moving right along, we have deferred examination. This one can buy you up to 36 months from the earliest claim benefit date. That's your provisional application if you filed one. This one is only available for new applications. You can't use it for continuations. Pretty easy to file, but it does count against the applicant in the PTA determination. As somewhat similar, but more limited in terms of when you can use it is the limited suspension of action. As the title implies, you can only file this along with an RCE. The delay amount is up to 3 months. Requires a showing of good and sufficient cause, which can be difficult to show. And I've provided some examples of this, which you can go through at your leisure. But applicants should note that this does count against them in the PTA determination. And finally, we have continuation applications. As I mentioned earlier with respect to the RCE, it's pretty frequent that we have applicants, who get a rejection in their first initial filing, and instead of filing an RCE, decide to proceed with a continuation application to take advantage of the resetting examination and search. So instead of buying themselves only 4 to 6 months with the RCE, they can get themselves 12 to 14 months on average. So with that, that's pretty much concludes my list. Do we have any questions?
Josh or panel, here's the question. In EP practice, we often use and there's a quote, abandonment and reinstatement procedure to buy more time when responding to an office action or to slow prosecution down. Is there similar procedures available in the United States?
Yes, there are. So in fact, so in the US, if you don't respond to an office action in the 6-month deadline, basically that case is going to go abandoned. There is a process to revive the case by basically filing a petition. I think it's called for unintentional abandonment, or maybe it's unavoidable abandonment. But the case law is pretty clear that if you cannot either use a petition, basically you can't use the petition if the decision to abandon the case was intentional, and it actually includes an indication on the form that you would file that you cannot use it to defer examination. So yeah, I think
that's a hard no.
Yeah.
Although in practice, if it's inside of 2 years on that abandonment, it would probably, the petition would be accepted, but you'd have a serious ethical question there, and probably have inequitable conduct in your case if it was ever tested. I would not recommend that, and I wouldn't sign it.
Any other questions?
Any other questions, Itna?
No questions. That was it.
Yeah.
All right, with that, I will turn it to Ed for his portion on speeding up.
Okay, I'm going to Ed. You should have control.
Okay, great. Speaking of speeding up, I will probably speed this up a bit because we're getting towards the end. But fortunately, most of the emphasis of this presentation has been about. I still can't control the slides, but I'll talk for a second. Has been about slowing down prosecution in the face of patent offices moves to speed things up. So, but there, even still, there might be reasons why you might want to speed up prosecution. Can you pass it to me, Wes? I still don't have access.
There you go. You should have access now.
Oh, okay, great.
And I forgot to remove Josh.
You may very well have a strategic reason to increase the speed of prosecution. So, for example, and I think we talked about this, or Wes may have talked about this a little before, you might have prospective litigation targets, you might have budget containment, obviously if you have shorter prosecution, fewer response to office actions, that will reduce your spend. You may have target numbers of issued patents you need to reach by the end of the year. The reasons are myriad. And actually, just for fun, and we'll do it really quickly, I think we have our last poll question, which is just tell us a little bit about, if you accelerate prosecution, why do you do it? And just for those reasons that I just mentioned. Just curious to see where everybody stands on this. As Wes was talking about during his portion, different people have different goals in prosecution. Some people just need to get a patent. Some people need to get a very specific patent. Again, we have a good mix. Interesting that nobody's fussing to having target numbers they have to reach. But I guess the plurality here don't accelerate prosecution, and that's not entirely surprising. So just moving right along. So at the outset, I want to say that apart from our classic PTO strategies for accelerating prosecution, I would recommend thinking about your pre-prosecution strategy as a way to advance your allowance date. Anything you can do to shorten the amount of time you spend preparing the application for filing will naturally move that issue date earlier in time, and you won't have to do anything at the PTO. And some of the straightforward ways to decrease that are to improve your, this should be IDF. And what I mean by this is information disclosure form. So a lot of companies have these disclosure forms that they have inventors fill out. Inventors sometimes aren't very good at filling them out, don't really know what to do. And then there has to be a lot of back and forth getting information out of them that if they were a little bit better trained, you might be able to get out of them a little more easily. Also, you can teach your inventors how to communicate more effectively with counsel like us. So very often with many of our clients, we deal directly with inventors and they don't always have a good idea of what they can say to us or how they should be communicating with us. And that can slow things down. We have, like I said, it's not a prosecution speed up strategy, but it can provide some benefits. And we have some resources on our website that you can avail yourself of on those topics, so I recommend it. Those links should be available in your materials, and if they're not, it's available on our website. But moving along to our classic PTO strategies, I think the first thing that comes to mind, the simplest one, are probably the special cases of accelerated examination. And what I mean by this is when you file a petition to make your application special. The special cases are when based on the applicant's age or health. And what that means is applicant 65 or older, applicant is in poor health. And poor health in this case means to the extent that the inventor might not be able to assist in the prosecution if it goes on very long, so sadly. And you would include that information in your petition. Advantages of this are the USPTO has a 12-month goal for completing examination. It's a goal, it's not a commitment, but it means something. And what completing examination in this case means is either it's allowed, it's abandoned, or you file an RCE, essentially. They take these up expeditiously. For example, can be within 2 weeks of granting special status, granting the petition. And it's easy to qualify if you fall into those categories. And there's no cost for the petition for these special cases. The disadvantages are it's limited applicability. You have to fall into one of those two categories. So accelerated examination is available in other cases with more limitations, however. One avenue you can take is to make special based on an invention that will materially enhance the quality of the environment, contribute to development or conservation of energy resources, or contribute to countering terrorism. These don't require a petition fee. That's the only reason they're special. But they do have some burdensome requirements that I'll get to after I discuss the general request for advancement of examination, which will cover any other subject matter, will require a petition fee. And then, of course, the advantages here are that you avail yourself of that 12-month goal at the PTO, and the action is taken up expeditiously, but the disadvantages are onerous. In order to enter accelerated examination under these categories, you have to essentially do a pre-examination of the application. And if you can see, scrolling by on the screen there, these are some of the requirements you have to go through. And I won't go through them individually, but you basically have to have a search done, and you have to go on the record about the applicability of the references to different claim terms. You have to agree to many different things that could possibly have a damaging effect on your prosecution history. Think very carefully before you go down this road, I think, especially because there are other options, which we're going to talk about. But before I do, I just want to mention that there's, just for fun, there's an other kind of accelerated examination, which is peculiar importance. I've never seen this in the wild. If anybody else has, please put it in the chat. We'd be curious to hear from you. This is when an invention is of peculiar importance to some branch of the public service. This is the MPEP's language, not mine. And the head of a department of the government requests immediate action for that reason. It's a request, it's not a petition. The advantages are you get VIP treatment. The disadvantages are I can't imagine many cases where this would apply. Maybe if you're in the military contracting space or something like that. But if you do it, tell us in the chat. Now, the most popular one, I think this is the one that a lot of people know about, is Track 1 prioritized examination. I call this pay to play. Basically, it's similar to the accelerated examination we talked about before, but what you're trading with the PTO for accelerated examination here is not doing their examination for them up front. It's basically you're trading a lot of money. So there are higher initial costs involved in prioritized examination at Track. So the advantage is you get that 12-month goal from the PTO. They take up your action expeditiously, and it's an alternative to accelerated examination. You don't have those same risks, and you don't have the same burdens. Disadvantages are pay to play means you pay. Large entity fee for just the request is $4,200 as of right now. But I wanted to mention that the cost of this petition by itself, it might be comparable to the cost of all of the compliance you have to do to enter accelerated examination, and it doesn't have that same risk of prosecution history problems that you would have. So I think many people who have the funds and the motivation to accelerate their applications probably are very interested in Track 1, typically. Now, there's another kind of prioritized examination. Oh, another thing I should mention is that only a limited number of these are allowed per year. This is a good thing to think about, actually, depending on where you are in the fiscal year. Right now, the maximum number that the PTO will do in a year is 15,000 of them. There is a place on the PTO's website where you can check to see whether they've reached that number yet. But if you're going to be doing accelerated examination, you might want to strategize a little bit to be sure that you're early enough in the process that they're not going to run out of Track 1 for you. And to point out, this is only available for new filings. Track 1 is something you file with a new application. But there is another there is another kind of prioritized examination, but I'll mention these graphics from the PTO first here. This is the result you can get from prioritized Track 1, which is that first office action pendency is 1.4 months. That's pretty good. They'll pick it up pretty quickly, and I think this is even more impressive. Petition grant to final disposition is 4.7 months. So you're getting to an allowance, an abandonment, or an RCE in 4.7 months. That's pretty good. So imagine you don't get an allowance, or you don't want to abandon the case and you go to RCE. track one would end at that point, except that you also have available to you prioritized examination for RCE. Originally, only track one was available, but then they decided that it might be useful to have some more flexibility. And so this is basically the same thing. It's pay to play, only instead of filing it with a new application, you file it with an RCE. It's similar to track one, basically the same sort of procedure. Advantages here are the same, similar to track one. It's available after the initial filing, with the RCE. Disadvantages are similar to track one, but keep in mind you can only file this once. So for your entire prosecution of an application, you may file more than one RCE, but you can only do prioritized examination RCE once. It does stack with track one. I think I alluded to that a little bit on the last slide. So you can file a track one, and then later you can file it with an RCE. Presumably you could file that with any of your RCEs. I'd imagine you'd file it with your first one, but only one of them is eligible. So another classic strategy for accelerating prosecution is patent prosecution highway. Obviously, this applies in cases where you're filing internationally as well as in the United States. Very often we'll file applications in a number of different countries, and most of the major countries are part of a patent prosecution highway of one form or another. There are different agreements that these are promulgated under, IP5, global IP, and then there are certain countries that have their own individual bilateral agreements with the US. And basically what happens under PPH is that if you have claims allowed in a participating foreign office, you can request fast track examination of corresponding claims in the PTO. And if you think about it, it's kind of like you get the benefit of, the PTO is giving you the benefit of work having already been done on the case. So they get a head start. You tell them, hey, I got these same claims allowed in another case. The claims are going to be the same claims. They'd have to be the same claims essentially. And if that's the case, then because they get a little bit of a head start, they can crib off of the other office a little bit. They will accelerate your examination. The advantages are generally they'll examine within 2 or 3 months from the grant of the PPH request. You don't need to file this at the time of filing, as in the other things that we talked about, although you do need to file it before the first examination on the merits. It's easily granted for qualifying applications. So if if this applies to you, it's not hard to get into this program, and there's no cost for this. So disadvantages are it's not subject to that 12-month goal. It's a different sort of program, but it's still picked up pretty fast. It doesn't apply to all countries. So if you're doing prosecution in maybe lesser known countries, or any countries really, you'll want to look into whether or not this is going to apply before you rely on it. And it does require that you conform the claims to allowed claims. So for example, if you've amended in the foreign jurisdiction to get the allowance, you would have to do something corresponding to that in the United States in order to apply it here, and vice versa. Okay, so another thing that was popular for a while was, well, I guess it wasn't popular for a while, was the first action interview pilot. And I only put it in here as a public service message because this pilot was discontinued last year. I'm only mentioning it in case anybody thought it was still available. This was a thing where you could, the examiner would do a search and would do an interview with you before the first action. And the idea was that you guys could come to an accommodation ahead of time. Evidently, only 0.2% of eligible applications actually participated in this, so they killed the program because nobody seemed to think it was worth their while. Another way to accelerate prosecution in the right circumstances is something called Quick Path Information Disclosure Statement. This is obviously in a specific circumstance. This is a situation where new art is received after payment of an issue fee. So if that specific circumstance applies to you, this is a way that things are faster than they used to be if you do this. In the past, you'd need to withdraw from issue and then file an RCE in order to cite art. So for example, in your parallel Japanese prosecution, you get an office action, cites a piece of art that hasn't been cited in the US yet, but you already paid your issue fee, you'd want to avail yourself of this. And what you do here is you file a petition to withdraw from issue and a conditional RCE, but you don't, the examiner doesn't have to reopen prosecution based on the cited art, and you get the RCE fee back if and a corrected notice of allowability if the examiner doesn't reopen prosecution. Advantages here are potentially avoid delays associated with reopening prosecution, and disadvantages are you have to front that RCE fee, and you have to be able to make one of the timeliness statements. I won't get into that, but that just basically means that you can only have known about the art for a certain amount of time. Now, this is the final thing I wanted to talk about. This is a little bit less a formal strategy from the MPEP. This is more having to do with your relationship with the examiner. And this was discussed a little earlier, having examiner interviews can accelerate examination under the right circumstances. A bad use of the examiner interview is to fish around with the examiner about what they'll allow. I think typically examiners don't have that thought through in mind. Good use is that if you have several proposals, if you have different kind of compromises that you're willing to make, you can kind of present them all to the examiner and see if any of those are acceptable. And then you could file a response with the best traction. That would save you having to make several different kinds of amendments and going through all of those to see what works. And then examiner timing, basically this means you could leverage the examiner account system to accelerate examination. This is actually less something that you do to them, although you could set up an interview based on this timing. Very often examiners will call you based on their account system. I just got one of these calls yesterday, as a matter of fact. Examiners have to meet production goals every 2 weeks, and they also have quarterly goals and then annual goals, and their year runs from October 1st to September 30th. So if you catch an examiner at a time where they need to make production goals, either to avoid discipline or to get added compensation, they can be very motivated to compromise with you on certain things. I'm not suggesting the examiner would allow something that's not allowable, but they may be more motivated to seriously consider your proposals at that case, or may volunteer proposals of their own because they'll have thought through it at that point. Advantages here are it's potentially very powerful. It can save a lot of back and forth if you're in a situation where you can compromise on your claims. And there are no fees for this. Disadvantages are it could be potentially dangerous if you don't have a good relationship with your examiner. And there's also a written record of what you discussed. So that's something to think about too before you go into the interview. So that's the end of our presentation. I'm going to throw it back to Wes for any final comments.
I just want to thank everybody for coming and staying to the end. And if there's questions, you can speak now, or you can always contact any of the three of us. We'd be happy to talk to you. And again, I just it's exciting to see so many people on and enjoying our webinar. So please, I think in the fall we'll have another one in the next kind of segment of our strategic prosecution. And we'll kind of be looking at more of how to keep costs under control while still advancing prosecution and obtaining quality patents. So if that interests you, which it should, keep your eye on the VK newsletters and posts, and you'll see more information about that. Anna, any other housekeeping?
Yeah, no, as Wes says, we are going to be doing these more the strategic prosecution sessions. If you want to find some of these materials, the VK website has them in our newsroom under Insights and Resources. All the webinars are there, and you can certainly go back and listen to those. So then on behalf of Wes, Ed, and Josh, and everyone at VK, thank you for coming, and we wish you a great afternoon.